Good morning, everyone. My name's Ann Shaw, and I'm with a realtor with Your Castle Real Estate, and I'm excited that you're here today. Um, Today's class is on the fundamentals of estate planning, and many have asked for this class because you have a lot of questions. So I've got Clinton Carlisle, who is a Broomfield attorney, that's going to do the presentation. And what we'll do today, a little housekeeping, is as your questions come up, you can put them in the chat box, but every question that you have will be addressed at the end. It's just a little easier that way. So I'm going to introduce, here's Clinton Carlisle, and he's ready to get started.
Yeah, hi everybody. So as Ann said, my name is Clinton Carlisle. I'm an attorney here in Broomfield, and my practice is centered around estate planning, which is what we're going to talk about today. That's primarily what I do, as well as probate after death. So I'm just going to kind of jump into it. Like Ann said, you can type in questions as we go, and I'll answer them at the end. Okay. So estate planning. What is estate planning? So it's a broad term that we use to describe any planning that has to do with during your life, if you're incapacitated or unable to handle your finances or your medical decisions yourself, as well as if you are to die with your plan. So planning for incapacity, it's a pretty significant chance that you will become incapacitated during your life at some point, either old age or accident. Without planning for medical decisions, you need a court-appointed guardian to make medical decisions if your relatives can't all get together and agree on a plan of action. That are made by a consensus of just interested persons, so spouse, children, close friends even. And then for your finances, you would need a court-appointed conservator. So to avoid that, we have some planning. So assets at death, we want to plan for who should receive your assets at your death, whether that's your children or other persons, how they receive them, outright, meaning they're ready for them today if you were to die tomorrow, or in trust, so you hold them for some period longer, and that's kind of the when as well. So when we're planning for death, we have a couple of things we consider. So we want to meet your objectives, and we also want to minimize expenses and taxes. So the estate and inheritance tax, federally, most people are not going to worry about federal estate tax. It's almost 11.6 million, meaning if you have less than $11.6 million in property, you're not subject to the estate tax. This could change. It matters what the exemption number is in your year of death. We know it'll decrease in 2026, but it'll still be 5 million plus. So barring any changes in law, most people are still not going to be subject to estate tax federally. For state, it varies a bit based on where you die and where you own your property. In Colorado, if you're a Colorado resident and own property just in Colorado, you're not subject to Colorado estate tax. But other states like Oregon and Florida have estate taxes, and there are varying degrees of severity. We also have something called generation skipping transfer tax. Again, that's only something that ultra wealthy have to worry about, 11.5 million plus. So we're not going to talk much about that. Then there's income tax. So everyone deals with income tax, and there are ways to plan your estate at death so that we can maximize the benefit your kids get and minimize how much income tax they have to pay. So there's something called a basis adjustment. And just briefly, some of your assets, not all of them, receive adjustment in their basis, which means if you bought your house at $200,000 20 years ago, and the day you die, it's worth $500,000. If you had sold just before you died, you'd have $300,000 in gain, the difference between what you bought it and what you sold it at, $500,000. If instead you die owning that house, your kids don't have to pay that gain. It's erased up until your date of death. So that's a rule that's been around for a long time. There's always talk of getting rid of it. In fact, Biden's proposal, I understand, would get rid of it. That's pretty politically unpopular, though, so I don't know if that will happen. But as of right now, if you die tomorrow, a lot of your assets, not all of them, do receive that adjustment. And then in our planning, we also just try to limit probate expenses. So just to give you a general overview of probate now, I'm not going to talk much about it in this webinar, but you're welcome to call, and maybe we'll do a future one on it. But probate, it varies by state. In Colorado here, if you're a Colorado resident, you would have a Colorado probate at your death. It is a procedure in which just your personal representative or your executor will file a court case, and the court is really not involved very much. No one will go into the courthouse. There's no hearings, nothing like that, so long as no one is contesting your will or doing anything to fight your will or your estate plan. So probate expenses, it's not too bad in Colorado. I usually estimate to people it's $3,000 to $4,000 after your death for a probate, for attorney's fees, filing fees, and other expenses. So it's not something you have to avoid at all costs, but it's something we can avoid if you have proper planning before your death. It's more important to avoid it if you own property in multiple states. Say you have a vacation home in California, then you'd have a probate in multiple states at death, and that would exponentially raise the costs. So talking more about what we do to plan for incapacity. We plan for medical decisions. So you have a medical power of attorney, and that is just a document that appoints who's going to make medical decisions if you cannot. This is similar to a HIPAA authorization you may have heard of. That's usually the same document, just gives someone the authority to get your medical information. A living will, a lot of people confuse a living will with a will. They're totally different documents. A living will is also called an advance directive. It's just a document which states what you'd like for life support if you're terminally ill or if you're in a vegetative coma. So you can state ahead of time, I do or I do not want life support. And then the last document for incapacity we ordinarily do is a general or financial power of attorney. This is just a document you sign now that allows your spouse or your kids or whoever you'd like to name to be able to sign for your behalf. Typically, if you're incapacitated, they would be able to go out and use this form to edit your bank accounts, withdraw money, do things for your care. Anything someone does under this document has to be for your benefit. There's no one policing that, but there's a lot of litigation and things that happen around when people do this wrong. But this document is really helpful, and it allows your kids to be able to access your funds. Some people think they can get around this by putting a child as a joint owner on a bank account. I'd strongly discourage you from doing that. The reason is there's a couple of them. One being if you put one child on the bank account with you as a joint owner and you have more than one child, the law says that at your death, the child who's on the bank account with you gets that entire account, whatever's in it. So if you meant to split that account with the other couple kids or something like that, it's not going to happen because you've only put one child on. Now the solution you might be thinking is, why don't I just put all my kids on my accounts? The other drawback of putting a child on the account is that now that account is subject to their creditors, including if they get a divorce or sued or anything like that. That account can be garnished just like it was their own asset. So a far better solution is to use this financial power of attorney that you would authorize one of your children or multiple of your children. You would give this document to the bank, and then that child could write checks for you and access the account. So then you wouldn't have the drawbacks of the other issues that I talked about. So at death, there's a lot of ways property passes. And typically, we will have a mix of all of these. No plan really just uses one method. So somebody like me is skilled at all of these, and we can help you say, this asset should pass this way, this asset should pass this way, and it'll be a cohesive plan. The ways this works is there's joint tenancy, beneficiary designations, will, trusts, and then intestacy. I'll go through each of these individually. So I'm going to start with the joint tenancy and beneficiary designations because they're very similar. So joint tenancy is the way you own property. It's often with a spouse, but not always. So this is like you're married and you own your house together. It's probably owned as joint tenants, which means that at the death of one of you, that property passes by joint tenancy to the surviving spouse. It totally ignores your will. It just goes according to this joint tenancy. So this issue here about one child named as joint owner, that's what I talked about earlier with the bank account. Beneficiary designations are very similar to joint tenancy, except it's on bank accounts, brokerage accounts, retirement accounts. So that is, for instance, when you open your retirement account, they probably had you designate who a beneficiary was. The beneficiary would be who receives the account at death. And again, that overrides whatever is in your will or other documents. So these are kind of the top level, what we look at first after you die to see where property is going to go. Each beneficiary designation is done at the institution holding the property, the Charles Schwab or the Chase Bank or wherever you have your property. So each of your accounts may have these, they may not, but from time to time you need to check them and update them as appropriate. For real estate, there's something similar here in Colorado called the beneficiary deed that allows you to leave your property to specific persons by beneficiary deed. That's something I do occasionally to help avoid probate for people. Because if property passes by joint tenancy or beneficiary designation, it goes around probate. So considerations we think about with joint tenancy and beneficiary designation is it ignores whatever is written in your will. If you named one child alone as joint owner on an account or beneficiary and your will says split equally between the three of them, we go by the joint owner or the beneficiary designation. Doesn't matter what you wrote in your will. You have to update it with every account. So if you have an account at Schwab and an account at Chase, you have to go to each of those banks and update it. It's not like a one document you sign in my office or some other lawyer's office. It can be kind of difficult to equalize gifts if you want to leave, say, 10% of your estate to your grandchildren or something like that. It's very difficult to do that in joint ownership or beneficiary designations. It also ignores whether they're minors or if they have special needs. The money is just going to go to them immediately at your death. There's no restrictions, nothing holding it for them until they reach a certain age. So the next one we'll talk about is wills. So wills are what people are a little more familiar with. That's what becomes effective at death. You can sign it during your life and you can change it any time up until your death or incapacity. Property in your individual name is all it passes. So that means that if you own property joint ownership, it doesn't pass by the will. If you own property with a beneficiary designation, it doesn't pass by the will. Just something in your name. So if you own the house, just you, something like that. A will can create trusts. Sometimes people say they have trusts and they really are talking about their will creates a trust. That's referred to as a testamentary trust. I don't use them very often because to use them we have to go through probate. And in that instance, I would rather use a different vehicle, which I'll talk about later, called a revocable trust. But a will can create a trust. One of the more important jobs of a will is that it appoints who's going to be your executor, who would open probate if a probate is needed, and a guardian for your children if you have children under the age of 18. Okay. The limitations to a will are anything that goes through a will or needs a will's instruction, generally going to need probate for that. And that, like I said earlier a little bit, it's going to need a probate in every state in which the property is. So if you own property in multiple states, multiple probates. The will is somewhat public after your death, has to be filed with the court, and people can request it if they have a good reason to. You also have to notice any heirs named in the will and any heirs who should have inherited under the will. Whenever someone files the will after your death and opens a probate, all those people have to be informed about it. So if you've written off a child, the will may not be the best place to do it because they're going to hear about it at your death, certainly. The next common structure that's used is a trust. So this is a trust that you would set up now, which is called a revocable trust. There's a lot of different kinds of trusts, but the one we're going to talk about here is a revocable trust, which means that you set it up now and you can change it at any time up until your death or incapacity. There's nothing that's restricting you from taking property out and getting rid of the trust entirely if you'd like. It's just a trust that you have set up to handle your affairs at death. So we actually do transfer your property into this revocable trust during your life. That can be your house. We might title your house into the trust. We might title some of your bank accounts. It depends on your specific finances and what your goals are during life and at death. But it can be the owner, the title owner of property. But anything in it is just for your benefit. So you're not giving away property by using this kind of a trust. It gives instructions, is its main job, for what happens if you're incapacitated? Any assets in this trust have instructions in the trust which say, if I'm incapacitated, I want this asset held or sold, things like that. And then at your death, it says where all your property should go. They're typically fully revocable. So we don't usually draft these trusts to say that you can't revoke it or change things. So you can change things, including everything in that document up until your death or incapacity. If it is properly created and funded, by that I mean we title assets into the trust or line them up some other way, then we can avoid probate with a trust. So that's one of the main benefits of a trust. They're also not a public record. So after your death, this trust does not get filed anywhere. It does not go to a probate court. It doesn't necessarily get sent to all your relatives. So if you have something you'd rather keep between just you and the people you've left property to, a trust is a good way to do it. The big limitations of a revocable trust are it is more expensive to set up. Typically, a revocable trust adds about $1,000 to your plan, just because it's more work for the lawyer to do or whoever you're using. They have to create this much longer document, a revocable trust, and then they have to create deeds and other things to transfer your assets into it and then coordinate all your assets with it. It does add some complexity to your plan because, like most people, you probably don't have a lot of familiarity with trusts. And so, when you come into my office or another lawyer, they'll go in depth on how the trust works and everything about it. But a few years later, you're going to forget all that. And then you're going to say, what is this trust I have? I don't remember it. So it adds some complexity. A trust also, you have to be somewhat careful to continue to update it, in that you have to, if you buy a new house, you want to title it in the trust. If you refinance, you might have to take it out of the trust and put it back in. You just have to be careful that you're continually looking at this over time so that your plan is still efficient at your death. A trust that you've also may have heard of is like a trust fund kit or something like that. So a trust for the benefit of someone after your death. We can create those in a will. That's testamentary is the legal term for that, or a revocable trust, inter vivos, we call that. Both of those we kind of talked about a little bit, but either of those kind of result in the same thing after your death. It's just a revocable trust is a little simpler getting there after your death. They can either be set up to delay distribution until whoever you're leaving money to reaches a certain age or ages. So a common one I see is people want their children to receive maybe a third of their assets at 25, a third of their assets at 30, and a third of their assets at 35. So they're not getting all of your money at once and are much less likely to blow it. You can also set up a trust so that it has some creditor protection. And by that, I mean if the child goes through a divorce or is sued, you can have their trust, their inheritance set up so their spouse can't reach it. Trusts are also extremely important if you have any children or beneficiaries with special needs, especially those on public benefits, so Medicaid or SSI or anything like that. These kind of trusts are very specific trusts. In this case, it's called a third-party special needs trust or supplemental needs trust. It is just a trust that you have to create during your life. It can't be done after your death. And once it's created, it's just set up in a way that that beneficiary doesn't have access to it, but that can be used for their benefit in a way that wouldn't reduce their public benefits. If you don't do this during your life and you leave money to someone on Medicaid or SSI or some other public benefit, you may force them to get off benefits and have to use your money first. So if you have someone in your plan that you want to leave to that is on public benefits, it's extremely important that you take care of this before your death. So the last way to pass property at death is intestacy. So that's a fancy lawyer word that just means I didn't do anything during life. I didn't plan because I didn't get around to it. So here we just rely on whatever state law where you died says. So you didn't have a will, you didn't have a trust. Now we're going to look at the state law. Typically that goes some or all to your spouse and then to your children. So That doesn't mean that it's going to go to the state. Some people think, well, if I don't have a will or trust, it's all going to go to the state of Colorado where you live. That can happen, but it's unlikely. There's a whole list of people who inherit if you die without a plan before the state does. But if you're someone that doesn't have a spouse or kids or grandkids, then your assets could end up going to the state if you don't plan. So in that case, you want to have a will or trust that says friends or charities or whoever you'd like to have it. So the concerns here are, it may not be what you wanted. You may have wanted to leave some to a friend or to kids in different structures, or all to your spouse or something like that. It's just the default. You don't have any control over how your heirs are going to receive assets. They are just going to receive it immediately at your death. The law also is going to choose who's your personal representative, the one that handles all of your collecting of your assets and probate at your death. It's also going to choose who the guardians for your children are. And that's often who you'd want it to be, but it may not be. And on the subject of guardians, even if you appoint a guardian in a will, that's still going to be subject to some court approval. This is guardian for minor children. So people often think, well, I don't know that I want to appoint my parents as guardians because they're getting older. It's not a huge concern because they can always decline to serve, or a court could say, well, they're not the right fit. Let's go to the next person you named. So a guardian is always going to be up to court interpretation. Intestacy also doesn't plan for your incapacity. So if you're in a nursing home for a long time and can't handle your finances, you'd have to go get that guardianship or that conservatorship with the court for someone to be able to help you. State law isn't going to step up and just have a document that they take to the bank. And last, intestacy is likely not going to be tax or cost efficient. The probate after your death is going to be needed if you have intestacy working for you, and it may have some more issues with it. Often there is some question of whether the intestacy really means this for your estate or this, and we have to ask a judge to tell us. Taxes might not be much as efficient. For instance, that step up in basis that I mentioned before, you may not get on all assets, or it may not work the same way. So that's kind of roughly how estate planning works. I will see if you have any questions now, and I'll go ahead and answer those. So let's see. There's no questions yet, so let me just talk a little bit more about probate since I have you here. Probate is just a general process in which we transfer assets to heirs. So it's not a big scary thing. It's not something you need to avoid at all costs. There's a lot of different types of probate though. So we have small estate probates. Okay, so sorry about that. I think we've got it back now. We had an internet issue. But I think Ann will ask some questions now for some common questions. I'd be happy to talk more about things she's seen and things that have worked well in her experience. Go ahead, Ann.
I'm a realtor that works with a lot of seniors, and why I've been encouraged to do this presentation is that I find that a lot of people feel they're prepared, and then when it gets down to it, they're not. I've had people that thought they were on the home title, the property title. Turns out that they weren't, and here they are. I've got a spouse that's dying, and we're rushing to get documents signed to show that the other spouse is on title. It did get done, but you don't like to see that. So that's why I've encouraged, and I'm glad Clinton's here today to cover some of the basics so that you can get started. It's one of those things where we'll wait and we'll do it later, or we'll talk to the kids, and years go by and nothing's been done, and then all of a sudden some kind of tragedies happened, or an incapacitation's the bigger one, where I'm talking to people now living alone in their homes in their 90s and really haven't done much, and I'm encouraging them to at least have conversations so that what your wishes are will happen. I did have a beneficiary deed once I experienced, didn't know much about it, but it worked out real well because the father suddenly was out in the driveway, had fallen and hit his head and passed away just suddenly, and the kids were left. There was a daughter and a son that were left with the home, but what he had done in advance was a beneficiary deed. And it worked beautifully for me. I don't know if it's always going to be a fit for you, but each of them were on this beneficiary deed. So when we sold the home, the proceeds were split and it went real well. I mean, the title company, they always want documentation to back whatever the proceeds or who's on title, that kind of thing. But once that's taken care of, it usually runs fairly smoothly. Those have been my experiences, and I just encourage you to talk to an attorney. Clinton's available as well to get some things done, or even just have some general questions, because I'm sure, just think over this, what we've just talked about today, what Clinton, is there anybody that has any questions? Because I'm usually surprised if we don't. We usually get quite a few questions.
Yeah, so let me tell you, while we're waiting to see if there's any questions, a little more about beneficiary deeds and why they're good and when they might not be good. A beneficiary deed, one of the main benefits of it is that it passes your real estate, your home or your other assets, real estate, without probate. And so it's very much like joint tenancy or beneficiary designation in that you can avoid probate by using it, as long as your other assets are also avoiding probate with one of those other methods. When it is a good solution is if you have a house that you want to leave to adults. So 3 kids or 2 kids who are adults, all could take the money now and be fine with it. A beneficiary deed is a good solution for you because it can be a real simple addition to just a basic will that allows us to avoid probate entirely with a very simple plan and allow your kids to take the asset and sell it immediately after your death without much issue. When a beneficiary deed is not such a good idea is if you're trying to leave money or your assets, specifically your house here, to minors who are under the age of really 21 in this case. A beneficiary deed would not be good in that case because they are not able to sign to sell the house after your death. And so using one wouldn't help. It would make things worse probably. It's also a document that ignores whatever's in your will. So if you have a beneficiary deed, you need to remember that you have one and continue to either update it if something changes or revoke it if you decide to do a different kind of plan. So it's just one of those documents that supersedes all else. So you have to be careful with it. But I like them a lot, especially in the case when you're a single older person who just has a couple assets and your house is your biggest. A beneficiary deed can be a good way to make a simple plan work efficiently and cost effectively. So it doesn't look like we have any other questions, so I think we'll wrap it up here. Feel free to call me anytime you have questions or send me an email. Anne can send out my information, but my email is just ccarlisle@stmlawfirm.com, or you can just, on our website, we have a contact us link. You can also call me at 303-469-7367, again on our website, which is just stmlawfirm.com. And this is Anne. You can also call her for any questions or for any real estate things you may have.
Yeah, if you have any real estate questions, I know a lot of people are concerned with what's going on in the market. If you have those specific questions, please call me, or you have my email address, ANNESWERS@comcast.net, and my phone is 720-320-7174. I want to thank everyone for attending today. I hope you found the information helpful, and I'll have another presentation coming up probably in the next month, and I'll get in touch with you on that one.
We do have one question that just came in from Carol. She asked, how is a beneficiary deed different from putting your house in trust? It's largely the same, really. They're just different vehicles to give the asset to persons after your death. A beneficiary deed is really an alternative to using a trust. It is just a way that if you don't need a trust for other reasons, a beneficiary deed is a good way to align your plan. If you already have a trust or a revocable trust, we would put the house in the trust. We would not generally use a beneficiary deed with that plan. Both ways avoid probate, get it down to the beneficiaries. It's just the beneficiary deed is a relatively new thing. It's been around for 10 or 15 years here in Colorado, but it's something not a lot of people are familiar with.
Another thought I've got is, I've worked with people who have a in-law, father or mother-in-law, who've now become basically a guardian over this person who's now become incapacitated. And so they've created a trust. And I'm not an attorney, so I'll leave this to Clinton. But my understanding is a lot of them that create the trust so that they have an account to run their normal, whether they're paying their taxes, the day-to-day, the electric bill, if the person's still living in the home, but they have help coming in. It's a way of streamlining maybe a balance, checks and balance. Maybe Clinton can address that, because I see that quite often, why some people have a trust, because I find some people are now using their own checking account, because I'm working with one right now that's using their own checking account to take care of the home, like paying for all the expenses. And I asked if he had a trust, and he said no. So Clinton might address that a little bit, because I'm seeing that too.
Yeah, a trust can be a good way to do that. It's just a vehicle that allows whoever you've appointed in the trust document, they're called a trustee, to be able to manage the assets of the trust, which can include a bank account, often do. They can include your house and other things, but whatever is in that trust, the person you appointed as trustee has the ability to manage those assets. It's very similar to a general power of attorney in that respect, that you're giving someone the ability to manage your assets. It's a little easier if it's in a trust, because banks are more familiar and comfortable with that, as opposed to general power of attorney. Not that a general power of attorney is a bad way to go, it's used often, but a trust can be kind of one vehicle that manages all of your assets during your life if you're incapacitated, or just don't want to handle your assets, or want a child to be able to handle them with you. Okay, so we'll wrap it up there. Thanks again for everybody joining us, and feel free to reach out if you have any questions.